Right. Good afternoon, everyone. I'm at-large Council Member Anita Bonds, Chair of the Committee on Housing and Executive Administration. The time is 1:25 p.m. on Wednesday, October 24th, 2024. We are conducting this hearing in room 500 and virtually via Zoom and streaming live to the committee's YouTube channel, EAL Committee. I'm calling to order the hearing to consider the following measures. Bill 25-0474, Parity and Workers' Compensation Recovery Act of 2023, Bill 25-0659, Public Incentive Transparency and Accountability Act of 2024, and Bill 25-0462, Government Recruitment and Retention Act of 2023. I want to remind today's witnesses that their testimony will be a part of the official record. For those submitting written testimony, that will also be a part of the record. So if you have not submitted it, please upload your testimony to the DC Council's hearing management system, or you may email it to CEAL@dccouncil.gov, and that's CEAL. We will first consider the Parity in Workers' Compensation Recovery Act of 2023, which is Bill 474. This bill was introduced on September 18th, 2023 by Chairman Mendelson. The bill amends the District's Workers' Compensation Act of 1979 to provide that the payment or award of compensation under the workers' compensation law of any other state shall not bar a claim for compensation under district law for the same injury or death, provided that any such award under district law shall be reduced by the amount of compensation received under another jurisdictional law. Next, we will consider the Public Incentive Transparency and Accountability Act, Bill 659. This bill was introduced on January 8th by 2024 by Councilmember Henderson. The purpose of this bill is to recapture public funds that are awarded to non-governmental entities that violates the terms of a contract, grant, incentive, subsidy, or tax relief agreement with the district. This bill requires government awarding bodies to review public incentive requirements and recipient compliance, as well as establishes reporting requirements for all recaptured subsidies. And then finally, we will examine Bill 462, Government Recruitment and Retention Act of 2023. This bill was introduced on September 18th, 2023 by Councilmember Pinto to address job vacancies in the district. First, it would establish recruitment and retention payments for certain difficult-to-fill positions. Additionally, it establishes a new director of recruitment and retention within the office of the city administrator. Finally, this legislation authorizes the execution of a campaign to encourage high school age students to consider careers with the Metropolitan Police Department, the Department of Corrections, and the Office of Chief Medical Examiner. With that, I'd like to recognize my colleagues who have joined today, at-large Councilmember Christine Henderson and Ward 2 Councilmember Brooke Pinto. And I would like to ask them if they have opening statements. Let's make them at this time. And I'll first turn to Councilmember Henderson.
Thank you so much, Councilmember Bonds. And thank you so much for holding this hearing today on all of these pieces of legislation, including my bill. the Public Incentive Transparency and Accountability Act of 2024. This bill would establish a new clawback mechanism for the district to recapture public funds that are awarded to non-governmental entities which violate the terms of the contract, grant, incentive, subsidy, or tax relief agreement with the district. Each year, as many of you know, the district invests millions of dollars in contractors, organizations, and individuals with the expectation that services and goods will be delivered as promised. However, while we have a strong systems in place, there isn't a consistent or universal process for recovering funds when those agreements fall short. Right now, the district can bar entities from future contracts if they fail to meet expectations, but recouping taxpayer money can be more challenging. This bill addresses those gaps by establishing clear criteria for recapturing public incentives and requiring the mayor to collect funds when appropriate. It also mandates regular reporting to the council, creating transparency around the amounts captured, who received the funds, and which agencies were involved. By closely reviewing the track record of repeat offenders, we can enhance accountability for both current and future partners. Past evaluations, including those by the Office of the Inspector General, have highlighted the importance of having better monitoring to avoid inefficiencies, delays, or potential mismanagement. It's critical that the district continue improving its oversight to protect taxpayer dollars. And I believe this legislation helps to build trust, not just with our residents, but also with our private and nonprofit partners by ensuring that public funds are being used responsibly. So I thank you, Chairperson Bonds, again for holding this hearing today.
Thank you very much. Councilmember Pinto.
Thank you very much, Chairwoman Bonds, for holding this hearing today on all of these important pieces of legislation. I want to focus on the bill that I introduced, the Government Recruitment and Retention Act of 2023. I actually initially introduced this bill as part of my broader Secure DC package, as we were focused and remain focused on improving public safety across the public safety ecosystem. And one of the clear concerns and issues that we are having across our public safety cluster agencies is around staffing shortages. We see significant vacant positions open. We see significant reliance on overtime, which then of course impacts staff burnout and morale. This is especially happening with our police officers, firefighters, our 911 call takers and dispatchers, and our correctional officers. And so we tried to fashion a bill that doesn't just focus on one of those specific agencies, but provides additional tools to incentivize the hiring across our public safety agencies. In this bill, we do things like establishing a director of recruitment and retention at the highest level of our government in the city administrator's office, authorize additional hiring bonuses, and direct agencies to focus on hiring campaigns. I will say that we are deploying a number of different tools and strategies when it comes to hiring, whether that's OUC having a bigger focus on hiring for high school students, whether that's the public safety cluster doing a huge multi-agency job fair several weeks ago where thousands of residents came to explore their options, whether that's the bill the council passed a couple of months ago to allow for retired police officers and firefighters to still maintain and earn their retirement benefits, but come back and work at OUC, or my bill, the DROP Act, to allow for firefighters and police officers to stay on the force while they're earning their retirement and continue to get paid. And so we are trying to be as creative and strategic as possible on the hiring side with bonuses and tuition assistance, housing assistance, but also on the retention side, making these jobs as attractive as possible and helping our senior folks stay as long as they can. So I'm looking forward to our continued partnership in this shared mission, Chairwoman Bonds, and I'm eager to hear from our witnesses today about additional strategies we can deploy. These staffing shortages are not shared only by the district. They are being experienced across the country, but I continue to believe that these jobs are so vital to the basic operation of our city and for every resident and visitor's right to be safe, that we have to stay focused on doing everything we can to fill these crucial vacancies. So thank you very much again.
Thank you. Thank you both very, very much. And we'll now turn to our public witnesses. I think we will first hear from those that are here. Who's here? All right, I'll just call and see if anyone is here. John Ferentine. Robert Brennan, I know him, I don't see him. All right, David Capson, you're here. Please come to the witness stand. We'll take your testimony. Tiffany Montgomery. And then Julian Petrella. Bernard Byron. All right, well, looks like you have the table entirely to yourself and all right, and please move ahead, sir, with your testimony.
Thank you. Good afternoon, Chairperson Bonds and members of the committee. I'm David Capson. I'm here on behalf of the Trial Lawyers Association of Metropolitan Washington, D.C. I'm also a partner in the law firm of Chase and Boscolo, and I'm delighted to be here to speak to you about in support of Bill 25-0474, Parity in Workers' Compensation Recovery Act, or Amendment of Act of 2023. If this bill is permanently adopted in the district, it will serve the interests of justice so that injured workers in our city are properly protected. DC has had a long-standing rule that if you accept indemnity benefits, which are known as wage loss benefits, or even just accept medical treatment benefits in another jurisdiction, you're completely barred from bringing your claim in the District of Columbia, even if there is valid jurisdiction to bring that claim. And this injustice must be remedied. With the emergency and temporary forms of the bill that have been in place for the many months since June of 2022, practitioners like myself of DC workers' compensation have been able to protect the rights of injured workers who would have otherwise been barred from bringing their claims. It's incredibly important that this bill be adopted as the law of the district so that all injured workers who meet the jurisdictional requirements may bring their claim in DC, even if insurance companies or their employers attempt to direct their claim to a foreign jurisdiction. This is especially so because the statute of limitations to file a claim for workers' compensation in the district is 1 year from the date of injury, where jurisdictions, our neighbors, Maryland and Virginia, are subject to a more generous 2-year statute of limitations. Making the law clear and closing the gaps caused by the periods in which the emergency and temporary legislation have expired will ensure a consistent application of the law for all injured workers, their employers, insurance companies, and the administrative court system. Now, many employees that work in the district in Maryland, in Virginia, they perform services for their employers in some or all of those places, and some of them in all of those places even in one day. And similarly, there may be workers who work principally in DC for a DC employer who get injured while they're in a foreign jurisdiction performing some temporary work. Now, these folks might have jurisdiction in more than one place to bring their claim. And what we see is that the insurance companies often try to get workers' comp claimants to accept benefits in another jurisdiction outside of DC, which would then bar them from bringing their claim, even if it's viable in the district, where they might have the best chance for an adequate and full recovery. As part of my practice, I regularly represent employees of the district who've been injured at work. The effect of this bill is so important because it can help eliminate the desperation that an injured worker faces when the insurance company tries to direct their claim to another jurisdiction. This desperation is caused when a multi-billion-dollar insurance company holds compensable, uncontested DC workers' comp claims hostage until the injured worker submits to their claim being administered under the laws of a foreign jurisdiction. These situations lead injured workers unknowingly to give up the best opportunity for full and adequate compensation because they're faced with a desperate choice between a slow system of adjudication and their urgent need for indemnity or medical benefits. The short-term desperation caused by having to decide whether to keep heat on in their homes, food on their tables, clothes on their backs, can lead injured workers to accept benefits in another jurisdiction at the direction of the insurance company. The law must change on this. We have to eliminate this desperate choice. I have a couple of examples that I outlined in my written testimony that I'd like to just highlight here. Take, for example, we have a Hispanic construction worker. He lives in Columbia Heights. He's the sole breadwinner for his family. He's got a wife and 3 small kids. He does not speak English. His only work experience is heavy manual labor. And even though he's been working at a big construction project at Union Market, for the last several months, the company decides to send him out to a job in Fairfax for a few weeks to help out. While he's out in Fairfax, he falls off a 15-foot scaffold. He suffers multiple injuries to his back, including fractured vertebrae, herniated discs, severely broken leg. He's got emergency surgery, hardware is placed in his leg. His employer sets up a workers' comp claim for him through an adjuster with a translator. They tell him that they're sending him claim forms to file his claim in Virginia, and that he must sign that paperwork and return it in order for him to get his workers' compensation check and his medical bills paid. He's desperate to get paid, and he's desperate to keep the lights on at his home, so he signs it. And it turns out that he's got to have some additional surgery in his back and his leg, and it leads to permanent restrictions. He never goes back to work in the construction industry. He may not ever go back to work anywhere again. If he is unable to bring that claim in the District of Columbia, that person would be limited to 500 weeks worth of compensation total. That's 9.5 years. Because of the way that statute's organized in Virginia. Whereas if he's able to bring that claim in the District of Columbia, he has the right and the opportunity to seek a claim for permanent and total disability if the case plays out in that way. I know I'm short on time, but I have one more good example that I'd like to just share with you if you'll allow me. Thank you. This next example involves wage stacking. Now, the district is a jurisdiction that allows for wage stacking, which means that a person with more than one job can add up the wages that they earn from all those other jobs and then get compensated based upon that. So we have a single mom. She is an Amazon driver, and she drives around all over the district, Maryland, Virginia. And she also works a second job at a diner in Maryland. She's rear-ended by someone just over the DC line in Maryland, and she lives in the district. I forgot to mention that at the beginning. Her employer provides her Maryland claim forms and says, we'll pay your benefits in Maryland, we'll pay your medical expenses in Maryland, but we're not going to do that for you in the district where she would otherwise have good jurisdiction. She cannot stack her wages in Maryland. It's not permitted, but in the district she can stack her wages. So she loses the opportunity to have the choice to bring the claim in the jurisdiction where she can seek the most full and adequate compensation based upon what her actual circumstances are. If this bill is adopted as the law of the District of Columbia, people like her will have the ability to pursue that claim in the district and pursue all the benefits and rights that they're entitled to. I have a bit more here, which is in my written testimony. I know there is concern that this could have a chilling effect for employers. The answer to that's a resounding no. Employers are required to maintain and pay for workers' comp insurance in the district. They're paying their premiums anyway. We also don't have an issue with double recovery, which is also mentioned in my written materials, but I know I'm out of time here, so I'll wind it up. But our neighbors in Maryland, they don't have a specific statute, but they have case law that allows folks to bring their claim into Maryland, even if they've got benefits somewhere else. It just creates a credit against future benefits. And Virginia does have a statute, but they treat it the exact same way. There's no double recovery. And this bill, I believe, will create a similar situation and bring us in line with our neighbors, and will, like I said, give injured workers the ability to seek all the rights, all the benefits, all the medical treatment, and the most full and adequate compensation. And thank you so much for your time. And for these reasons and more, we ask that this bill become permanent in nature.
And thank you very much for your testimony. I do have just a few questions. You mentioned in your testimony that when you cite the example of the heavy construction worker, labor worker, you say if the law doesn't become permanent, he is limited to a maximum of 500 weeks or 9.5 years of compensation in Virginia. So if this bill is enacted on a permanent basis, how does that change the situation for it? Give us the understanding as to how this bill will change his situation.
Right. In that example, and this happens a lot, where the insurance industry understands that folks like that they're paycheck to paycheck, essentially, right? They work.
Can you move the mic a little closer? Yeah,
Sorry about
thank
that.
you. That's
The
much
insurance
better.
industry
Now you
understands
can
these
hear.
people work paycheck to paycheck, right? So if they're unable to work and they don't have a stream of money coming in or income coming in, they can hold this person hostage and say, okay, if you want to bring your claim in the district, go find a lawyer, file the paperwork, we're going to contest it. You'll spend at least 6 months or more in litigation. You're not going to see a penny of workers' compensation until that time, until the court orders us to pay it. Whereas if you sign these forms in Virginia, you'll have a check next week and we'll pay your benefits and you can go get treatment, go get better. But they don't tell them that they're limited to that 9.5 years, that 500 weeks, because that person wouldn't meet the statutory criteria in Virginia to make a claim for permanent and total disability. Or if they did, it would be quite hard. DC does not have those statutory restrictions or those statutory requirements on a claim for permanent and total disability. So if that hypothetical or that example plays out the way that I described, where that gentleman is not able to return back to work in any capacity, in Virginia, he would be limited to 500 weeks worth of compensation. In the District of Columbia, he can claim and potentially be awarded permanent and total disability, which would provide a weekly workers' comp check for him for the rest of his life, plus a yearly cost of living adjustment. And it's a way more full and adequate path for recovery for that person rather than being limited to the 500 weeks or 9.5 years, especially if they're in their 20s, 30s, even 40s.
And for this type of injury that the worker has succumbed, in Virginia, is there a ceiling as to how much the compensation can be in comparison to the compensation if it were filed in DC?
There are caps on or maximum and minimum compensation rates in the district and in Virginia and in Maryland. They don't always match each other perfectly. I think that's a negligible point when it comes to this. Another point that I would make just about your question about Virginia is that in Virginia, the employer or the insurance company, in a claim that they're going to accept as compensable, will provide a panel of physicians that the employee must pick from in order to undergo their treatment. And oftentimes, those physicians are approved by the insurance company, so they tend to be a little more favorable to the insurance company than they do to the patient. The District of Columbia allows its injured workers to pick their doctor. They have what's called an election. So that same person, rather than being subject to a list of doctors who are probably out in Virginia somewhere, because they don't tend to usually provide a local list. Sometimes they do, but generally they have them be out in Virginia. That guy's living in Columbia Heights, right? He can pick a doctor in the district or anywhere that he wants if he's allowed to bring his claim in the district, where he's going to be subject to that panel of doctors that the insurance company picks for him in Virginia. So he has a better opportunity to seek medical treatment with someone he's comfortable with rather than at the direction of the insurance industry.
All right, I think I'm understanding that you're mentioning that if his claim was filed in the district, he would be able to see a physician anywhere in the DMV.
Correct.
I see. But if the claim is filed or when it's filed in Virginia, he's limited to a panel of physicians exclusively located in Virginia.
Most of the time, but it's exclusively at the insurance company in that claim produces the list of doctors that he's allowed to pick from. Anything off that list is not an authorized physician that they will pay for and that he could see, unless they contest the claim, which is a whole other situation, but not part of this example.
Okay. So if this injury had happened in Maryland, what would be the circumstances? What would be the manner in which it would be handled? You've told us about Virginia. Tell us about Maryland, because we're in this DMV and I want to try and understand that.
Yeah, Maryland, it would probably be a little bit more beneficial for that person in Maryland than in Virginia. The difference, and this is very weedy, and I don't want to get too in the weeds. The difference really comes at the time of permanent partial disability benefits, or if the person was to claim that they were permanently and totally disabled. Maryland has this sort of convoluted tier system of disability that involves a lot of complicated math.
Well,
But
does
it-
it
but other-
include, is it maximum of 500 weeks, or is it 1,000 weeks, or is it into
It's-
perpetuity?
The ability to make a claim for permanent and total disability exists in Maryland. It exists in Virginia too, but there are strict statutory requirements that must be met. And in that scenario, that person he probably doesn't meet the statutory requirements to seek permanent and total disability in Virginia.
All right, so help me understand the difference in all three jurisdictions as it relates to the woman with stacking. You use these as examples, so that'll help us.
Yes, thank you. So the district allows for wage stacking, which if you have multiple sources of employment, you can bring all of those streams of income in and have them added up gross before taxes. And then that number helps us determine a person's weekly compensation rate. So it's 2/3 of your average weekly wage, which in the district is calculated based upon the 26 weeks immediately before the injury, or if you're not there for 20, some people don't work for 26 weeks before they get hurt, so you just use what's available. Maryland does not allow for any wage stacking whatsoever. So you only receive compensation for the employment where you're injured. Virginia allows for wage stacking in limited circumstances where the employment is substantially similar. So for example, someone who is an Uber driver, but they also drive a bus, maybe that would be substantially similar. But if you were a Amazon delivery driver and a waitress at a restaurant, those are not substantially similar jobs that would allow you to stack those wages.
So in essence, I think I'm hearing that this particular piece of legislation would remove complications from having to figure out how we handle employee injuries.
It would remove an obstacle that exists for a lot of people in these scenarios that I outlined are just two, but when a person's injured and they're desperate and they don't know what the future is going to hold, and they have an opportunity to have some whatever amount of money coming in versus fighting it out for months and months to pursue what's probably better for them in the end, they're faced with a really tough choice there. And this eliminates that obstacle.
Okay. In your testimony, you also mentioned that businesses in the district are already paying their workers' compensation insurance premiums. So this suggests to me that the argument is, well, they're paying it so they can therefore pay it out to whenever an employee is injured. It makes me wonder, are we saying that in Maryland and Virginia, there isn't a workers' compensation insurance premium that's paid?
Of course there is.
Okay.
Of course there is. The point here is that there may be an argument from the other side that, if this law changes and folks who receive benefits somewhere else are able to come into the district, these businesses in the district who are carrying in workers' compensation insurance are going to be forced to pay higher premiums. And we don't think that holds any water. They're required to maintain workers' compensation insurance by law. They're paying their premiums anyway. It really has no effect on their ability to set up shop. DC's pro-business. That's great. This bill, the effect of this bill becoming permanent should not have any negative effect on businesses coming into the district, operating in the district, and continuing to do business in the district.
So your thinking is that the permanence of this bill will not create an environment where the employee base in the district will have to pay higher insurance rates.
I don't think it should on its own. And you know, I'm sure data exists already in the past 2 years because there are periods of time. I have them.
Do you have some from?
Well, I don't have the data, but I know there's periods of time when this bill has been in effect. So it's
Yes.
been the law of the district for various points of time from
Okay.
June 22 to September, end of September 22, and then temporarily from September to 22 to May of 23, and then various points. There's been a congressional review period.
Yes.
And you know, there may be data that exists about that. I don't have that data. I'm happy to look into that and submit something if we're able to locate it. But I can't imagine that this bill alone would cause insurance premiums for those businesses to skyrocket so much that it would cause them to close up shop and leave the district.
All right. Well, thank you very much for that. Just one second. Thank you. All right, well, thank you very much. My questions are primarily geared to our government witnesses, so I'll add a couple of questions I had for you to this list. So thank you very much for your testimony.
You're welcome. Thanks so much. It's been great to be here.
Yes. We understand that that Jillian Petrella is here. No? Oh. she's
Council
on
member,
the
I'm
Zoom.
present on Zoom.
All right, on Zoom. All right, so now we'll take those that are present on Zoom. All right, Ms. Petrella, please go ahead. All right.
Good afternoon. Thank you, everybody, for holding this public session. My name is Jillian Petrella, and I am president of the Association of Compensation Insurance Attorneys, which essentially is the DC workers' compensation defense attorneys, those of us who represent the employers and the insurers. So I know Mr. Capson well. We have many cases together, both of our firms. I'm here to present the opposite side, I guess, of this Parity and Workers' Compensation Recovery Act and raise some concerns that I feel that we are concerned have not been brought up to the council in the past. This amendment solves absolutely no problems that exist. It did not solve any problems, and it is only going to create problems. Mr. Capson mentioned employers and insurers having the ability to hold claimants hostage and direct where they file their claims. That has never been the case. Employers and their insurance carriers have never been able to do that. To be perfectly clear, DC and Virginia allow voluntary payment of workers' compensation. Maryland, you have to file a claim form, but all you have to do is file it. Where there is concern, there was a hypothetical, or I believe it was an actual case, or a hypothetical that was brought up regarding somebody who was injured in Virginia and told, you know, I cannot pay you until you file claim forms in Virginia. And thus risking that benefits are denied for months on end. Employers and insurance carriers are under very specific obligation within the District of Columbia, within Virginia, and within Maryland once the claim form is filed to promptly pay all claims that they know are proper. So what an employer and carrier does, if they are denying a claim in DC that they would otherwise accept in a different jurisdiction, most likely they are denying jurisdiction. I actually had a case with Mr. Capson's firm with a gentleman who was injured day 2 on the job in the District of Columbia. My client did not dispute any of that, but it was our position that it was a Virginia claim. And so while the claimant did go several months without any benefits, that was only because that claimant's attorney on his behalf filed a claim in DC, and it took over a year of litigation for the DC, the two levels of litigation, to keep telling the claimant that my client was correct, there was no DC jurisdiction. So if we want to talk about delays, those delays that you see where an employer and a carrier are denying a claim that they would not deny if it was filed in another jurisdiction, they're denying it because of jurisdiction. It has already been the case in DC that an employer and carrier cannot trick a claimant into accepting benefits in another jurisdiction without their knowledge. So to be clear, the injustice that Mr. Capson spoke about was the injustice of a claimant voluntarily accepting a different jurisdiction. So what this amendment does is says, even though a claimant voluntarily chose to pursue their claim and receive benefits under a different jurisdiction, say most likely Virginia or Maryland, they can now change their mind because they don't like what's happening to them in those other jurisdictions. And those were exactly the examples that you heard. A claimant has a claim in Virginia, but they're like, you know what? I can get more money someplace else, I think. So this amendment does not change or fix any injustice. The injustice spoke about was a claimant choosing their jurisdiction voluntarily. What this amendment does do is create many problems that are unanswered by the amendment and that will have to be answered through years of litigation if this amendment is made permanent. For starters, although the amendment suggests that there is a credit for compensation paid in another jurisdiction, it gives absolutely no guidance for how that credit is supposed to be applied. Temporary total disability rates can be incredibly different we'll just stick with the DMV area, in DC, Maryland, and Virginia. If a claimant files a claim in Maryland and an employer pays benefits in Maryland for years at that rate, and then a claimant files in DC because they like the permanent partial disability better in DC, how does that credit work? Is it a dollar for dollar credit? Is it a week's credit? Can you apply the overpayment of temporary total disability to a credit for permanent partial disability? This amendment does not answer any of those questions. This amendment also raises serious concerns about whether or not the District of Columbia is continuing to recognize full faith and credit and collateral estoppel. The amendment talks only of compensation, but seems to suggest it would include benefits as well, which again is a question. This amendment doesn't make clear whether it's talking about just compensation or benefits, because those are not the same thing. Compensation is just money payable. Benefits are the medical benefits, the vocational rehabilitation benefits. So would this amendment mean if a claimant files a claim in Maryland and then later files in DC, are the medical and vocational benefits still under Maryland law and only the compensation to the claimant under DC law? That doesn't seem to make sense for any party, but that's what this amendment would make happen. But if instead we do include benefits, let's say a claimant files a claim in Maryland voluntarily, gets medical treatment, and is seeking a surgery, and goes to a hearing, litigates whether or not to get surgery, and that is denied. What in this amendment stops a claimant from then turning to DC, filing their claim in DC, and making the employer and their carrier relitigate the question of surgery? Everything about the examples that we heard today highlighted exactly why the claimant's bar, the claimant's attorneys, want this amendment. They want to be able to pick up their clients and take them from jurisdiction to jurisdiction, cherry picking which benefits are best, requiring employers to have attorneys in all three jurisdictions to litigate one injury in all three jurisdictions. This amendment speaks of parity. presumably parity with the laws in the states nearby, Virginia and Maryland. Parity cannot be approached in a piecemeal basis. There are massive differences between Virginia and Maryland and DC, how they handle workers' compensation. And each of them exists as a system that makes sense within itself. By DC changing one aspect of its law without taking a look at how that works within the DC system, workers' comp system overall, it breaks the functioning of the DC Workers' Compensation Act. If the council were concerned about parity, the answer would be to revisit the DC Workers' Compensation Act as a whole and look at how the DC Workers' Compensation system functions and works or does not work for claimants and employers. That also raises the question of, what about public sector DC Workers' Compensation Act? If the concern is about parity, should we not also be addressing parity with the Public Sector Workers' Compensation Act, where many DC government employees find themselves unable to even obtain counsel because there's no way for their attorneys to get paid under that act? So those people, those injured employees of the District of Columbia, are left trying to work a system themselves unrepresented because they cannot find counsel. They have the right to counsel, but they cannot find counsel. This amendment solves no injustice. The injustice spoken about was imaginary. Again, I want to reiterate, if one of my clients denied a compensable claim for no basis, the penalties that my client would have to pay would be stiff and fierce. This amendment does not speed up the process for claimants. It does not protect the claimants from injustice, because again, the claimants voluntarily choose where there are multiple jurisdictions available to them. They voluntarily choose which jurisdiction. And so what we heard today is just claimants bar trying to find ways to increase money payable in fees and costs to them for claimants who had or could have had viable workers' compensation claims, if not for their attorneys playing games with jurisdiction just to try and get a bigger payday, where the primary purpose of workers' compensation should always be getting the claimants the medical treatment they need, getting it as quickly as they need it, getting them back to work as quickly as possible, and making sure they are paid while out of work. That happened before this amendment. This amendment does not solve any problems with that issue.
Ms. Petra, have you completed your testimony?
Yes.
All right. Well, it would have been great if we had been able to see you. We have nothing in writing from you, so I'm requesting that you submit written testimony so it can be a part of the official record.
And I apologize. The camera was not working, so I apologize for that.
All right. Okay. Well, we missed your cheerful face. Thank you very much for that. I don't have too many questions. I have very little to go on. I tried to take notes as you were speaking. I hear the case that you're making. So at this point, all I can say is thank you. Once I get your written testimony, we may have follow-up questions for you. All right?
Thank you.
Thank you very much. We also have anyone else on? That is it. All right, very good. With our public witnesses in total. All right. Okay, so we will now move swiftly to our government witnesses. And I'm going to ask Director Hall if he will come up. I understand that he wants to be first, and he's going to talk about another item, and then we will move back to, I think, Dr. Rodriguez and Nancy Hetman and Jamie Scott. Okay. And Dr. Hall, you're on when you're ready.
Okay, thank you. So good afternoon, Council person and Chairperson Bonds, Council Member Pinto, and members and staff of the Committee on Executive Administration and Labor. My name is Charles Hall, and I serve as the Director of the DC Department of Human Resources. And I want to thank you for the opportunity to testify regarding B25-0462, the Government Recruitment and Retention Act of 2023. Human capital is the most valuable asset in every organization. Without skilled and knowledgeable employees, the district would not be able to perform and provide critical functions and services. According to several Society for Human Resource Management, or SHRM, articles, at the core, all employees want to work for an employer where they can make a difference, where they can receive career development and growth, where they are respected, and where their well-being matters. It is especially important for us to implement the core principles because the U.S. faces a labor shortage. According to a recent article by the Director of the Global Employment Policy and Special Initiatives at the U.S. Chamber of Commerce, organizations across the U.S. and across industries are facing unprecedented challenges trying to find enough workers to fill open jobs. Simply put, the number of jobs open and the number of people to fill them are outnumbered by openings over people to fill them. To overcome this reality, the district works to ensure that prospective and current employees view the district as an employer of choice. While we recognize the council's concern with the number of vacancies present at select agencies and agree that these vacancies need to be filled, DCHR believes that the work and activities described in B25-0462, the Government Recruitment and Retention Act of 2023, are actively occurring and that the legislation is not needed for this work to continue. B25-0462 calls for establishing a new Director of Recruitment and Retention within the Office of the City Administrator, who would be responsible for identifying mission-critical positions at agencies and identifying why positions are difficult to fill and/or have attrition rates. This director would also be responsible for submitting annual reports to the council and working with agencies to address hiring and retention issues. We recognize this bill's effort to provide additional oversight and address workforce challenges regarding difficult to fill positions. However, we believe the creation of a new director-level position may be counterproductive as it duplicates existing functions already performed by agency human resource departments and adds an additional layer of bureaucracy that can slow down the hiring process. Agencies already know what positions they need because they work on the ground. Agency directors and staff have the best firsthand insights on their recruitment and retainment challenges, whether it be morale, compensation, or other factors. As the best practices and challenges for recruiting hard-to-fill positions may vary, empowering agencies with the flexibility to address their needs individually is critical in the current labor market. Introducing a new director can lead to inefficiencies, as the process of coordinating between multiple layers of oversight and analysis may slow down decision-making rather than streamline it. The quarterly reporting requirement the bill requires of the mayor may also create an unneeded burden and shift the focus from recruiting to providing reports. Instead of creating a new director position, along with additional reporting requirements, DCHR recommends partnering with the council to provide semi-annual in-person updates on hiring and retention of critical positions and empowering agencies to address their individual needs. Regarding retention incentives, the bill provides retention and recruitment incentives of up to $5,000 for difficult-to-fill positions that specifically impact public safety. Additional monetary incentives for hard-to-fill positions already exist. In accordance with our personnel roles and our published guidance, agencies already have mechanisms to provide hiring and retention incentives for hard-to-fill positions. A hiring bonus is a one-time payment that may not exceed 15% of the maximum rate payable for the grade held by the employee that occupies a hard-to-fill position. A position can be shown as being hard to fill based on the existence of multiple vacant positions, the significant length of time a vacancy has remained unfilled, and resignation of multiple employees in the position. Like a hiring bonus, agencies can also provide employees who occupy a hard-to-fill position an additional income allowance of up to 15% of the maximum rate payable for the grade. Additional income allowances are paid in addition to an employee's salary for 1 or 2 years. The incentives provided in this bill are unnecessary, as the district already has well-established mechanisms that provide additional compensation. The bill also directs MPD, the Department of Corrections, and the Office of Unified Communications to work with a contractor to develop and execute a campaign for high school students to pursue a career within the agencies. Finally, the bill calls for the Office of the Chief Medical Officer to establish an internship program to encourage high school students to pursue a career in OCME. DCHR already has comprehensive recruitment strategies that target potential employees, including incentives that connect with students through local high schools, colleges, and universities. DCHR understands the complexities of the current labor market and has implemented several strategies to assist partner agencies in hiring for mission-critical positions. First, DCHR has hosted quarterly in-person hiring events. In FY24, close to a total of 7,500 prospective employees attended the events, and nearly 500 job offers were made. To provide candidates with the needed resources to be successful, DCHR hosts several hiring event preparation sessions that focus on resume and interview best practices and tips, and how to market yourself at a hiring event. In FY25, DCHR will focus on enhancing these sessions to community conversations that not only provide tips and best practices but highlight why the district government is an employer of choice. In addition to DCHR hosting events, DCHR has attended hiring events at local colleges and universities, including the University of the District of Columbia and Howard University. Nonprofits such as the Boys and Girls Club of Washington, D.C., and the Anacostia Library Stop, Shop, and Go Job Fair. DCHR has also attended multiple events sponsored by the HBCU Connect. To further attract prospective employees, DCHR has enhanced marketing our employee value proposition on various social media platforms. DCHR has also, or currently, has a partnership with LinkedIn to post all district government job announcements using a process called wrapping to give high visibility to hard to fill positions within the district. We can highlight the posted positions from the DC Careers website also with identified hard to fill positions. Currently, we have 50 slots available to highlight vacancy announcements for hard to fill positions. In the past 3 months, the job postings on LinkedIn have garnered a total of 170,033 views and 18,609 clicks from individuals applying for these positions. As not all prospective employees may use LinkedIn, DCHR also increased our marketing on social media platforms, including X and Instagram. This year, DCHR posted a series of current employee testimonials, sharing their positive experiences working within the district government or at DCHR. The series emphasized the benefits of working for the district, including the ability to impact the lives of district residents, the supportive work environment, and career growth opportunities. In addition, DCHR posted Tip Tuesdays that provide tips for applying to district positions online and hot jobs that highlight vacancies across the government. We also work with partner agencies to host agency and job-specific events. As we have demonstrated, DCHR and our agency partners are already engaging with residents and are constantly finding new ways to deepen the district government's talent pool. Allocating resources to a contractor-led campaign may divert attention and funding from existing impactful recruitment programs. In conclusion, while the intentions of B25-0462 are admirable in addressing workforce challenges, we believe that the provisions of the bill are duplicative of efforts already underway. Between DCHR's and partner agencies' strategic efforts using their knowledge and expertise, the district is proactively addressing recruitment and retention challenges while balancing the realities of the job market. We have demonstrated success in our engagement through hosting hiring events, partnering with educational institutions, and enhancing marketing efforts from various platforms. And we firmly believe that empowering individual agencies to address their unique recruitment challenges with flexibility is a more efficient and effective approach. As such, we do not believe legislation is needed to fulfill the spirit of the bill, and we recommend continuing our existing work to enhance our hiring initiatives. We look forward to working collaboratively with the council to ensure the district remains an employer of choice. I'd like to once again thank the committee for the opportunity to testify and for your time today, and I welcome any questions you may have.
Thank you very much, Director Hall. I do have a few questions. I think you make a case for effective recruitment and retention. I guess my question is more related to how do you demonstrate success? I'm interested in these 170,000 views and 18,000 clicks. And I wondered from those, what did it yield in the way of, I guess, selection and placement in the positions?
Excellent question. So I think what it does is it broadens our ability to have a larger pool of candidates to select from, which means we have access to more highly qualified persons who we know will potentially be eligible for the jobs that we have to fill. So it's giving us it's casting a wider net so that we have more people to select from, to screen, and ultimately interview, hopefully to hire as well.
And from this that you just shared with us, the 18,609 clicks, how many of those clicks resulted in an actual hire?
So that is a number that could be tricky to ultimately drill down to, simply because when persons are ultimately hired or apply, they have to actually self-identify how they learned about the job. So we would be counting on persons ensuring that they did identify they learned about the job through LinkedIn and then make sure that that carries throughout the process. But I'm willing to, of course, look into what we
Would you,
can
I
draw.
think that's very important because we're presenting testimony that stipulates that this is a system that works. And it would be very, very helpful to have that in some report for the official record. These bills are very important. My colleagues are very anxious to get some results from them. And if we're going to mark these bills up, I want to have a complete package before we mark them up. So that information would be really, really important. You mentioned also that you spend some effort in enhance marketing our employee value proposition. What's that?
Yeah. So what we want to do is we want people to know that there is actually a value to being an employee of district government. And so what we're doing is we're making sure that we get the story of DC government out there through our marketing campaign. That it's not just about having a job, that you'll become, of course, part of a community. You'll have an opportunity to have direct and indirect impact on the lives of our residents. That you'll have access to a comprehensive wellness program, that you have the opportunity to move throughout the government. You know, it's not just because you come in one agency in one position doesn't mean you'll be stuck there. So the opportunity opportunity for promotions and for movement is something that the government offers. Those are the things that we want to make sure that we're marketing and we're pushing, because we believe that DC government is an extraordinary place to work, and we want people to see that value proposition.
Okay. Well, you know, this committee is very concerned with getting DC residents jobs.
Yes.
Do you have reports that would indicate the number of DC residents that have applied, let's say, applied in FY '24, and how many were placed in jobs? I also would like to know, I know it's easy to be in Oklahoma and read about a vacancy in DC and apply and be selected and move in. So I want to know if any data you have on those who lived in DC less than 2 years, 2 years or less, and those that have lived here longer that are ultimately selected. Because I hear from community that kids from here, young people from here, and they are looking for jobs, and it's very hard for them to be selected. And we're talking about our own government, where their mothers and grandmothers are taxpayers, and they're trying to be taxpayers, but they can't if they don't have income. And I'm really concerned as to what are we doing here? This $22 billion annual corporation, and how do we treat those that contribute to it? So I'm really very concerned. So any little glimmer that you can share would be very helpful. Maybe in the next 2 or 3 weeks would be very helpful.
Yes, ma'am. We will compile that information. The mayor, of course, has a priority that district government has DC residents in it as well, that's a priority. And I've heard that
I understand.
from you,
yes.
shared as well. And it is something that we do take very seriously. And that's
Yeah,
one of the reasons why we're trying to broaden our getting into the community as opposed to just the community coming to us. So when they come to our hiring fairs, we want to make sure that DC residents have been empowered and received information so that they're better prepared and better positioned to actually get positions in DC government. We've been working with Morca. I went and I did a presentation for them, for returning citizens, on how to better
Yes.
prepare yourself for that. Those are things that we're actively doing, and we're being very intentional about, because we hear and we know that it's a priority for the mayor. We've heard your concern about it as well, and we are being very intentional about ensuring we provide
And
those
I will
opportunities.
be asking, I may have to do it through the Budget Support Act, but I'll be asking for a report on a monthly basis of the special constituencies and how we're doing in getting them into the workforce. You mentioned returning citizens. I would like to add to that our senior citizens, our veterans. And when I meet young veterans, and they have a job, a very menial job, and they have been individuals who work on like the missile systems, I'm very concerned.
And we share in that concern. One of our quarterly hiring events actually is dedicated to veterans, which is coming up. So on November the 19th, we'll have a hiring event. It's one of our quarterly events. The first 2 hours are actually dedicated to veterans and their families. And so we're working with the Mayor's Office on Veteran Affairs. We're reaching out intentionally to organizations that may have connections to veterans to ensure that they're, number one, informed about the event, but can attend the event, because our intention will be, as persons come, that hopefully we'll be able to offer them contingent employment offers.
All right, and I would think that this bill that you're examining today, Recruitment and Retention Act, would lend itself to some of what you are you say you're already doing. And that is you're already recruiting and placing individuals in the Office of Unified Communications, MPD, Department of Corrections, and I would imagine also fire and emergency. Okay.
Yeah, with the exception of MPD. So MPD functions as they're still, of course, under the mayor's authority, but they have their own personnel authority. So they hire, they recruit, they do all of that on their own. Of course, we support them in endeavors. They do attend our hiring events. The public safety and justice event that they recently had, we attended and we supported in that endeavor. So there's still a support system for them, but they manage their recruitment and retention efforts.
And when you say they manage their recruitment efforts, when you say you support their efforts, what does that really mean?
Excellent question. So making sure that they're included in our hiring events so that they share the positions they're hiring with us so that we can highlight those. On careers, if there's a position that we know is in MPD that they'd like to highlight, again, we have those spaces where we can highlight it. Making sure that when they attend, that they are visible to persons so that they can speak with candidates who are coming. And again, in our recent support of the PSJ hiring event that they had, making sure that we were present, guiding them through some of the best practices that we've utilized so that they have additional information on what might be beneficial for MPD.
So in our big government and our $22 billion annual corporation expenditures, you're informing the public that your department is responsible for managing a few, or I'll say maybe 2/3 of the agencies. The other agencies that provide services to the public have their own system, and they may or may not choose to work through your operations.
That's correct. They have the opportunity to set up a memorandum of understanding with us that we can provide HR support to independent agencies.
All right, okay. And I guess as someone also in the public, like you, we're in the public, I think it would be so easy to know I can go to one location and see what's available in my government that I'm paying my tax dollar to, right?
Yes, ma'am. You mean as far as vacancies?
Yes.
Yes. Yes, so there is a website that persons can go to where they would be able to see job opportunities in the mayor's office, as well as MPD, the school system, and DC government. And they can go to together.dc.gov, and you're going to see all of that information when you click on careers. You can also go to the careers page, which is what DCHR manages, and you'll be able to see additional government positions there as well.
I mention that because I recognize that we have, our government is set up, at least our budgetary authorities are set up where we have the agencies that are considered the municipal services, which are primarily under the mayor. And then we have the school board services, which is our educational cluster conglomerate, as I call it. And we also have our county functions like, what is that, DC Water, and I guess DPW is also, is that one under the mayor?
Yes, ma'am.
Okay, okay, all right. And I guess what would be a state one as we're thinking about this? Since we're a four-part government, well, I'll ask Dr. Rodriguez when he comes on. I'm sure he has the answer at his fingertips.
I'm sure.
My point to the public is that, you know, we are, the District of Columbia is just much more than just the city and the way in which we have to manage the monies that are our budget. And in doing so, you're making a fair a point by saying you're already doing this, but I'm not sure. I'm not sure that I hear your testimony, but I'm wondering if we have a new position in the city administrator. Does the city administrator have a breadth beyond the so-called agencies that fall under your purview?
As far as,
Would the city administrator have the MPD, all of those entities we just talked about, the educational, all of that reporting into the city administrator?
so I know, the reporting structure, like Chief Smith at MPD would, work directly with the mayor. So I'm not sure how much they work with the
Yeah.
city administrator. I think, to your point, what we would have is we would have an additional layer of what we currently have. So you'd have another person removed from the agency that would need to get in touch with the agency to collect the information, which is what we have now. The difference, though, is that DCHR works closely with the HR community in each agency. For instance, today, we had all of the HRAs, the HR advisors from various agencies, all at DCHR, where we were providing training and giving updates on information. This additional position would not have that connection. It would not have that direct engagement. So there would be an additional layer of removal that does not currently exist. Whereas right now, what we can do is work with agencies to have them report in to us vacancies, work with our HRSA team on recruitment and staffing, making sure that we're getting hiring done in the appropriate time. Those are things and connections that already exist in the government, and that we're literally paying persons currently working for us to do. This bill would say we're gonna take government money to add an additional layer, add additional funding to, in essence, duplicate matters and responsibilities that are already in place.
So let's just think outside the box for a minute. If we had this additional position with the focus on speedy recruitment and then follow up with all kinds of processes for retention, wouldn't that help us in our government? Since these are vital areas when we talk about first responders and we talk about our public safety, your community, you don't see them needing or having or improving the recruitment process? If you could think
Yeah.
outside of your box.
Yes.
Yes.
So a couple of things. One, as Councilmember Pinto stated, this is not a challenge that's unique to DC. So the assumption that we'd have one person who would come in and be able to resolve what's a nationwide problem of actually finding and recruiting police officers, 911 call takers, I think that while it might be thinking outside of the box, it may not be thinking within reality, because we know across the country, this is an issue. No matter where you go, finding 911 call takers is a challenge. Not just finding them, but retaining them is a challenge, because it is a position that requires people on a daily basis to engage in work that is traumatic, not just for the people calling in, but for the people taking it. And so I don't think that one person would be the silver bullet to solve what's a nationwide problem. I think that what we can do is we can continue to use the systems and mechanisms we have in place to continue to fortify and support the agency HR teams to make sure that we are not just focusing on the HR specific, like recruiting them, but ensuring, one, that we're telling the story about DC government. Why do you want to work here? Making sure that we're informing people about the wellness opportunities that are available to them and going beyond what we might offer to other agencies. It needs to be more specific to OUC. This bill is not looking for this person to do that. DCHR is doing that and can continue to do that. And, I've had specific conversations with Director McGaffin about what does your wellness plan look like for persons who we know on a daily basis are encountering trauma? What does it mean for the way that we might staff or the way that we might set up various schedules that people have? Those are the things that I think are specific to what we already do in DCHR that we can help be thought partners and implement in different agencies.
Thank you very much for that. I also would like to request that we get information from your shop that is going to require your coordination with those that are not under your umbrella at this point, but from MPD and from the corrections and the Unified Call Center, and I think also from police and, from fire, the fire department. Because I think what we need to understand is how many have they recruited in 2024, FY 2024, and how long did it take to, after the recruitment, to get the person on board, hired? And I think that would be very helpful to us.
Okay.
And if the employee is still with them as of September 30th, because most of the recruitment was done much earlier in the year.
Got it.
If
We
we
will
could
work on
get
that.
that little window to understand what's going on.
Yes, ma'am.
I
So
think that would
recruited
be
in
helpful.
2024 and retention as of 9/30.
Correct,
Got it.
yes. And maybe we should ask, in what month were they recruited? That would be very helpful. Go back to my maps, okay. That's here. In your testimony, you stated that the work called for in this bill is already ongoing, and I think you made a case for that. And so I want to know, you said there is existing a 15% signing bonus. Can you give us an example of a position and the salary and the corresponding bonus, that what this 15% really means?
So it will vary based on the position, but examples would include call takers in OUC.
All right, let's do a call taker then.
I don't have the exact salary with me, but I can get that information for you. But those are offerings that we know that OUC is working on. MPD has I think it's a 25K hiring bonus that they've offered as they're seeking to recruit persons. And then once someone is hired within 18 months, they get a salary increase from 60 something to 70 something. I don't have the exact numbers, so I want to make sure that I don't throw a number out there that's not correct. But that is another
All right.
example of something that's currently in place.
All right, can you get us
Sure.
little scenario regarding a call taker at entry level and then a police officer at entry level, so we can understand what those numbers really mean?
Sure.
And maybe to be thorough, we'll ask for the Department of Corrections officer first year. I forget what their terminology is.
Got it.
And I ask these questions because, and I know that this bill is being proposed because we see serious staffing needs that are not being met. And so One way to understand the situation is to look at the numbers. Another way is to do some of what you already begun or you just testified you're doing with the Unified Communications Office, and that is looking at how you handle stress. You know, we customarily across the nation have always done that with our police officers, but we haven't done much with anyone else. And there are other occupations that are in the first responder domain, and we need to think more holistically about how we manage these things.
That's right.
Not just with stress, but scheduling and what does it really mean? So I'd be very interested to know periodically how you're doing with that part of the equation. I would imagine even our the group, the DPW employees, those that have to deal with constantly dealing with the public, you know, our residents that refuse to put their trash in the trash can. And one lady told me, my neighbor refuses to put her trash in a bag and therefore it's not picked up and therefore it ends up all over the alleyway. So, but it must be very disheartening to come by every week and know that you're going to see this and it's not going to be handled properly.
Agreed. I think the health and well-being of our employees needs to be a priority. And
Yes.
we are working very diligently. I think I can say I'm very proud of the wellness approach that we've taken. Our chief wellness officer in DCHR works on a weekly basis with wellness champions in agencies to ensure that they are being very thoughtful about how they are assessing the needs of their agencies and the workforce in those agencies to tailor wellness opportunities specific to those agencies. Because to your point, the challenges faced in DPW might be different from those in DDOT. And so we don't want a cookie cutter approach. We want to make sure that we are speaking directly to the needs of those persons in our agencies.
All right, and I hope you're also looking closely at the Department of Behavioral Health and their team, because they have some real challenges within the public domain.
Got it.
You know, so, well, we've got a whole bunch of agencies that, you know, have these difficulties, you know, now, but thank you very much for that. And I must say that I think in conversations with you some time ago, at the beginning of the year, it compelled me to do something here at the council with my colleagues. So, you know, and it was a hit. Okay, big hit. So thank you very much for
No
that.
problem.
And finally, can you just talk a little bit about your high school outreach efforts? Because that seems to be an area where we thought that you would pursue in order to recruit and have an opportunity for those young people to become in the folds, particularly in our public safety.
So we do currently have a in-school program specifically targeting high school students. I am also scheduled to meet with Deputy Mayor Kine to talk about additional ways that we can work to ensure that we are establishing avenues for high school students to seriously begin to think about working in district government. And so that is something that we currently have in place as it relates to a program. We want to find ways to enhance that, but also, as you're saying, like get into the schools to make sure that we are in front of them and making sure that persons are aware that your government is a place that is open to you for employment opportunities, and we want you to come to work for DC government.
I appreciate hearing that because it seems to me that's a captive audience of DC residents. So, sorry to hear that it's just now getting off the table and into maybe activation, but please do that. I mean, it will make a difference, a world of difference.
The program has, just so we're clear, the program has been in place for a while.
Yeah,
Our enhancement effort is what's, taking place now.
all right. Well, thank you.
Mhm.
And did you want to testify on any of the other, one of the other two bills?
No, ma'am, I'm just here for this.
All right, okay, I appreciate that. And I didn't swear you in, but I know that your testimony is always official. All right, so thank you.
Thank you.
Thank you very much. The next. I think, okay, all right. I was endeavoring to have a government witness on the issue of Bill 474, Parity in Workers' Compensation Recovery Act, but I don't know if there's anyone else here who would like to testify on that. Oh, not everyone stand up at the same time. We can only take 4, but thank you very much for that. Okay, we will move now to continue our government testimony, and I believe we have witnesses for Bill 25-0659, Public Incentive and Transparency and Accountability. And so we'll ask Dr. Rodriguez and Director Nancy Hateman and Mr. Jamie Scott to join us at the witness table. And you can begin when you're ready.
No, now you can. Okay, great. Thank you. And good afternoon, Chairperson Bonds, members and staff of the Committee on Executive Administration and Labor. I am Chris Rodriguez and have the privilege of serving as the Assistant City Administrator for the District of Columbia. I'm joined by my colleagues, as you mentioned, Chairperson, Chief Procurement Officer Nancy Hateman, and Jamie Scott, Deputy Chief of Staff for Policy and Performance, and Interim Director of Business Development and Strategy within the Office of the Deputy Mayor for Planning and Economic Development. Thank you for the opportunity to testify regarding B25-0659, the Public Incentive Transparency and Accountability Act of 2024, and to provide remarks on the processes by which businesses and nonprofit entities conduct business with the district. I want to start by emphasizing that the Bowser administration is committed to ensuring we maintain the trust and accountability of district residents, community-based organizations, and businesses alike. A key element of my role as the Assistant City Administrator is supporting coordination and logistics throughout district government operations. This requires working alongside the mayor, the city administrator, and agency directors to identify and enhance efficiencies in district government operations, ensuring we can perform and provide critical functions and services. Now, as you know, the district offers community-based organizations grant opportunities to support the delivery of a wide range of programs and services for district residents, businesses, and visitors. Extending federal and local grant funding allows district agencies to best leverage resources, boost efficiency, community engagement, and provide residents pathways towards success. While we recognize the Council's concern with ensuring recipients of taxpayer money deliver goods according to the terms of an agreement, the proposed requirements in the Public Incentive Transparency and Accountability Act of 2024, we believe, would duplicate processes and procedures already legislated locally and federally. Regarding compliance, the proposed legislation seeks to ensure services are delivered in a manner that is compliant with the terms of the original agreement. Currently, any district agency who receives and awards federal grant dollars must adhere to the administrative requirements, cost principles, and audit requirements for federal awards outlined by Federal Code 2 CFR 200. For local awards, the compliance review is agency-specific and outlined in an agency's policies, procedures, and related grant terms. As written, this bill would be duplicative of local and federal administrative and compliance processes that agencies are required to adhere to currently. Additionally, the legislation does not address nuances that exist when different grants require different terms and types of engagement. Much of the grants and public incentive processes are not one size fits all, and the proposed legislation would cause process and resource challenges if executed as is. Having discussed the grant-making process, I'd like to briefly turn our focus to the procurement and contracting procedures that are essential to the programs and services district agencies provide. The Procurement Practices Reform Act of 2010, the PPRA, established the Office of Contracting and Procurement, which is administered by the Chief Procurement Officer. The proposed legislation directly conflicts with the provisions of the PPRA and DC Code 2-351.01 that gives OCP's contracting officers the authority to determine a contractor's responsibility, to terminate contracts, and to initiate claims by the district against contractors. Under the PPRA, the CPO already has the authority to suspend and debar contractors from receiving awards under circumstances like those contemplated in the legislation. The statement of introduction issued by the sponsors of this legislation states that, quote, this legislation would give the district tools to recapture public funds that are awarded to a non-governmental entity that violates the terms of a contract, grant, incentive, subsidy, or tax relief agreement with the district. As far as the legislation would apply to contracts, OCP already has the tools provided by the PPRA to deal with a contractor that violates the terms of its contract. A new duplicative process would impact OCP's ability to act in accordance with the PPRA when it deals with contractors that violate the terms of their contracts. Most glaring in the proposed legislation is the delegation of judiciary functions and common law claims, such as breaking a contract or fraud, which are typically filed in DC Superior Court. Delegating additional adjudicatory authority to the Office of Administrative Hearings, OAH, is duplicative locally, as the PPRA established the Contract Appeals Board, or the CAB, and deems it as the exclusive hearing tribunal for claims the district brings against contractors. The district must remain a vigilant party when conducting business with all partners, as well as being cognizant of any unintended negative impacts to district contract administration. The legislation also aims to support transparency for public incentives, which we support. The Office of the Deputy Mayor for Planning and Economic Development, DEMPED, has a strong pre-screening process in place, and with every district and federal grant, DEMPED conducts a risk analysis on the recipient before making the grant. Additionally, all DEMPED contracts, grant agreements, and incentive agreements already include mechanisms to stop future payments, disbar parties from future district contracts, collect reports on a recipient's use of funds, conduct audits of a recipient's use of funds, or recoup payments for noncompliance or default via the legal process. Because of DEMPED's rigorous pre-screening process, these are provisions DEMPED must rarely use, but they exist for instances precisely like the ones this bill aims to mitigate. Implementing a new program adjacent to the provisions and mechanisms already existing in contracts and agreements would require additional personnel resources for all impacted agencies, especially considering the amount the district would reasonably expect to recoup. In conclusion, we do not believe legislation is needed to fulfill the spirit of this bill. We have demonstrated the duplicative efforts already underway across OCP, DEMPED, OAH, and other partner agencies, and firmly believe that continuing our collaborative work is a more effective approach to enhance efficiencies across and expand transparency within district government operations. We look forward to working with you to ensure that the district continues to develop streamlined processes for those seeking to do business with our government, and to ensure residents know we are a responsible, trustworthy, and transparent government. I would like to thank you and the committee for their time and welcome any questions you may have for us. Thank you, Chairperson.
Thank you. Thank you very much for your testimony. And Ms. Hagman, do you have any statement or your
The testimony reflects my
All right.
comments.
Okay, and you as well, Mr.
And
Scott.
likewise, yes, thank you.
Thank you. Thank you very much. A couple of things I wanted to see if we can't discuss. You mentioned, Mr. Rodriguez, that the legislation does not address the nuances that exist when different grant requirements are made for different terms and type of engagement. Can you just put on the record what that really means? Examples would be very helpful.
I can also turn to my colleagues for this, but I guess I'll start. Having had experience administrating federal grants, like at the Homeland Security and Emergency Management Agency, I know that there are federal guidelines and requirements that even within our grants or the grants that were administered by my former agency, down to the project level. And so there are extremely nuanced terms within those grants in terms of what issue areas we can cover, how the grants should be administered, how they're overseen. And so I would use that example to illustrate that oftentimes there is that federal oversight as well to ensure compliance at the district level, which adds a layer of oversight and transparency and accountability to our processes. So I don't know if you have anything else.
Thank you. I would just add to that. In the case of a grant that DEMPED may issue, if it's locally funded or federally funded, as the Assistant City Administrator said, there may be different requirements on how we may recapture funds or conduct audits of a grantee depending on the source of funds and the amount of funds. And DEMPED may also issue grants that are cost reimbursements, that a grantee performs work and then is reimbursed for costs. There may be grants where a grantee is paid in tranches depending on milestones that they've achieved, or there may be grants that are advances to achieve a project objective. And so it may be that we would consider, for example, a grant in which a grantee has performed work and been paid for that work, but then fails to perform future work, that they would not get paid for the future work they haven't performed yet. But we might think differently about funds that are advanced to a grantee and the grantee fails to perform versus a payment that is due to a grantee that they're no longer able to perform in order to receive the funds. So those might be some examples where different federal or local requirements would impact the way we would audit or recoup funds.
All right, and I take from your comments that the public needs to understand that we have a variety of ways and variety of products that you are, I guess, monitoring or tracking. And therefore, within each of the products, there is a so-called recovery process. Am I correct in that? In other words, I was very curious. I think you made a comment about implementing a new program adjacent to the provisions and mechanisms already existing in contracts and agreements would require additional personnel resources. All of the impacted agencies, especially considering the amount the district would reasonably expect to recoup. And I think it's this money that there is a sense that this money is out there where somehow we have not, as a government, gotten all the money back. The money that wasn't expended appropriately or was expended inappropriately, so to speak. And so that's why, it's my understanding, that's one of the main purposes of this legislation. Is that what you're thinking? And you've sort of buttressed their approach because you are saying that you've acknowledged that there is a lot of money out there somewhere, and we maybe have not gotten it all, you said would reasonably expect to recoup. That implies that we would have to employ a small army to do the gathering of this money, but at least we're acknowledging that there are resources out there that belong to our government.
Well, Councilmember, what I would say to that is that when there are breaches of grants, I'm going to speak for grants in particular, and I know Director Hateman is the expert on contracts, but in grants in particular, when there are breaches of a grant or one of our subrecipients is not in compliance, we use all the resources of our government to recoup funding. And in the case of what was just mentioned earlier, in some cases, those grants are reimbursable. So the subrecipient will spend the money first and then present evidence of expenditures and compliance with those grants. And if they're not in compliance, we would not reimburse.
I think the legislation does not speak entirely to in some enforcement mechanism, much like what we know the OIG has enforcement mechanism as it relates to Medicaid fraud. And I'm just wondering if this would be a avenue that we should pursue. In other words, trying to think through whether or not there is a need for some uniform standards. If you have a grant, your grant agreement must contain these 5, 6 provisions and any other thing that the granting agency needs. If it is a contract, and of course, Ms. Hateman will be able to tell me this. She's been doing it for a long time, she and I. I don't know. I'm just wondering if that's something that we need, some sort of uniformity that would be sort of a guidance, or do we have it? We may have it.
I can speak on behalf of DEMPED that our grant agreements all have standard language around a grantee's, our ability to audit the grantee's use of funds to determine that an expenditure was disallowed, and to hold the grantee in default if they fail to perform, and then to demand the repayment of funds if we've determined that a cost is disallowed or the grantee hasn't performed. So our grant agreements, at least for DEMPED, already include that language, and then we would pursue the recovery of funds through the legal process already.
All right, and so DEMPED can pursue recovery of the funds. So help me understand how that's done.
In I think recent experience, we haven't had to do that because where we've held grantees liable for expenditures that were not allowed or in default, we've followed the process as outlined in the grant agreement to give notice to the grantee that the expenditure was not allowed or that they're in default, provided the grantee the opportunity to cure or if they fail to recover funds. And I think in the limited number of cases where we've needed to do that, the grantees have returned funds.
All right,
So-
this is very important because, for instance, I can understand when there is a contract long-term, such as the housing contracts, 30 years, 40 years. And no one will be here then, from what was expended, let's say in 2023. We probably won't be here 40 years from now. And so, and we probably will not have those kind of records maintained the way we maintain them today. So how does the government really retrieve those situations in I'll say Department of Housing and Community Development that are due now, that were put in place many years ago, and they're finding they have a hard time. And I'm just wondering if that's the case in generally with the contracting in our government. And if the language in this piece of legislation would be helpful.
I'll talk about contracts for goods or services construction. We
Okay.
don't do 30 or 40-year housing contracts
I know.
in my agency, but the process for us is very prescribed. It starts out with the PPRA. It talks about the authority of the district to bring claims against a contractor when we, the district, feel that we are owed money or they have not performed in accordance with the contract. So we start with the statutory right there. We then have our regulations in 27 DCMR, and that further explains in either chapter 37 or 38, I forget which one, what we have to do to present the claim against the contractor, the kind of documentation we have to provide, and what we need to inform the contractor. Then that initial decision on whether money is owed to the district is made by the contracting officer. Then if the contractor refuses to provide the money or disagrees with that, then they have a right to appeal to the Contract Appeals Board. And then that proceeds at the Contract Appeals Board. And the procedures at the Contract Appeals Board would be in compliance with the Administrative Procedures Act, just as I know the legislation references that act as well. And so it's very straightforward in terms of what our authorities are and what we need to show. Now, we do reflect all of that in our contract terms. We have templates for our contracts, and in part of our templates, we have something called the standard contract provisions, which is a document that talks about our rights to bring actions against the contractor and the rights that they have as well. So for us, it's fairly well clearly laid out in the documents that we have.
All right, well, thank you for that. Do you happen to have with you today the amount of outstanding contract remittance that is in your department?
I do not have that with me today.
All right, can we get that in about 2 or 3 weeks, please?
Certainly.
And if you would break it down into, you said goods and services, and what does that really mean? I think maybe it would be better if we did it by the various clusters, because I think contracts and procurement manage all of our contracts now, almost, except for DDOT, right? Or do
Well,
you-
actually, DDOT contracts are under the authority of OCP, or Office of Contracting Procurement, but there are some agencies such as Department of General Services and Child and Family Services, which are not under us. And then there's other agencies that are considered independent, such as libraries, CFO, Chief Financial Officer. Those agencies are not under us, but DDOT is.
All right, well, I would like to ask then for itemization by agency then. That's the only way we'll have a sense of this. I think that would be very helpful. And as we talk about grants, can we get something that grants as it relates to social services, grants as it relates to public safety? I'm trying to think of, would there be another particular area where we do grants? Yes, of course, DOEE does grants, housing does grants, seniors do grants. Yeah, so it's a lot of different grants. If we could have, yeah, we would like to take a look at that as a part of, for this bill, to understand what we're talking about. And that would also include DC, housing, yeah, where they're alleged more than $1 billion. That's there. I think that would begin to I want to be able to paint the picture of what the reality is and what are we really talking about when we talk about a bill as broad as this. And there may or may not be electricity. So, but we need to make sure that we have covered all the bases. So we have the information. I did want to ask, I think, Ms. Haitman, you pretty much, you covered the contracts. I am very curious about what happens, how is breaking a contract handled? But I believe you gave us the scenario when you, at any time that there is a disposition on a contract, it goes to the cab. Am I correct?
If the contractor disagrees with
Yeah,
the
dispute.
decision, yes.
Okay, okay. And do we have something similar with the grants programs?
I can speak for the DEMPED grants that the grant administrator for DEMPED would send notice to the grantee if they fail to comply and demanding repayment of funds. And the grantee can write back to contest that appeal. And we would work that through the agency's process.
So am I hearing you correctly that you do have a process in place?
Yes.
Okay. All right. All right, I think that kind of covers those. And now to the main questions. All right. The monies that are collected, are they returned to the general fund? Or what happens if they're collected? How do they?
If the grants, are you talking about grants and contracts?
Yes, grants and contracts, yes.
Generally speaking, they would be returned to the source of the original fund. In most cases, that is the general fund.
Okay, so if they're returned to the source, and let's say it's a grant that DEMPED has, does it go directly back to, after, I know it's made payable to DC Treasurer. So that check, does that then go into the accounting for DEMPED? Or does it go into this big box that is the general fund? I mean, how is it handled? How do we find it on a ledger?
Well, Councilmember, it would depend on the grant itself. It would depend on when we go back to the originating agency, the grant-making agency, whether they plan to spend that money again. So I think those determinations would be made by the city administrator, by the Office of Budget Performance Management, and by the agency itself.
All right, I'm asking this because I know that even within my committee, DOES has the ability to collect money from contractors, their fines, when they do not comply with first source. And what happens with that money? I've been trying to track it. Where does it go?
We can get back to you on that. We can get information for you on that.
Yeah.
You're referring to first source in particular? Yeah. Okay.
Yeah.
Yeah.
What happens when a fine is paid? Where does the money go? Okay, thank you. And there may be other funds like that, around.
I would just add that sometimes where the money goes depends on the legislation that authorizes the collecting of the funds, because sometimes they say they go to the general fund. Sometimes legislation may say it goes back to the agency
Okay.
as well.
All right, that's great to understand. I'm interested in, now that we have all this compliance in this committee, interested in seeing where we need to sort of tighten up to better track the business of our government. And so that's the nature of this. So thank you. And I thank you. I think we completed them all. I indirectly had asked a lot of the questions that we had.
All right, thank you,
Let me
Councilmember.
just check. Yeah. All right. Thank you very much. Thank you for being here with us today. Mhm. Here. All right. Somewhere, it's here somewhere, I know it. All right. Well, I want to thank all of our witnesses today and remind our witnesses to please submit your testimony in writing. This concludes our hearing today on three important proposals for government acts, and I'll record that the time is now 3:20 p.m. and today's hearing has concluded. Thank you. You know, it did.